Hosting our discussion today is Cully Stimson. Mr. Stimson is Senior Legal Fellow and Manager of the National Security Law Program in Heritage's Catherine and Shelby Cullum Davis Institute for International Studies. He is a widely recognized expert in national security, homeland security, terrorism, and crime control. Before joining us here in 2007, he served as Deputy Assistant Secretary of Defense for Detainee Affairs, where he advised both Secretaries Rumsfeld and Gates on global detention policies, including in Afghanistan, Iraq, and Guantanamo Bay. An accomplished trial lawyer, he worked as a prosecutor at the local, state, and federal levels, most recently as an assistant U.S. attorney here in the District of Columbia. Apropos of today's discussion, however, he is currently a captain in the United States Navy JAG Corps Reserve Component. Over the last 22 years, including 3 tours of active duty, he has served as a Navy prosecutor, defense attorney, Joint Special Operations Task Force JAG, Force Judge Advocate for the Commander of Amphibious Group 2 in East Africa, a senior instructor at the Naval Justice School, also been stationed in Europe as part of the U.S. Naval Forces Europe during the conflict in the Balkans, and most recently as the Deputy Chief Trial Judge of the Navy Marine Corps Trial Judiciary. Please join me in welcoming Cully Stimson. Cully.
Thank you very much, John, and welcome to all of you who braved yet another cold, snowy day here in Washington, D.C. Spring is somewhere in our future, hopefully not too far away. We're delighted to partner with an organization called Our Soldiers Speak to bring you this program, and our distinguished speaker today, Israeli Defense Force Military Advocate General, which means the number 2 JAG, Colonel Eli Bar-On. At first blush, you might think that our speaker and I have a very similar experience in uniform, given the relative similarities between my military background and as a Navy JAG for the last 22 years, and Eli's distinguished service for the last 2 decades. But you would be mistaken, as the challenges and everyday threats to the State of Israel are far different than the threats to our country. Since the vicious, unprovoked attacks on our country on September 11, 2001, our country has been at war in a state of legal armed conflict. But that conflict, for the most part, has been waged thousands of miles away in Afghanistan and Iraq. And although we remain vigilant against potential terrorist attacks on our own home soil, we don't live day by day here in America with the very real threat and at least thought of existential annihilation in the backs of our heads. That's not the case in Israel, where the ticking time bomb scenario is a very real possibility. Our self-declared enemy is Al-Qaeda and the Taliban and associated forces. Israel, on the other hand, has many enemies, including some state sponsors of terrorism located in their neck of the woods. Which brings us to today's program. The IDF, or Israeli Defense Force, is a battle-hardened, tested national defense force. Comprised of an Army, a Navy, and an Air Force, the IDF is comprised of male and female conscripts. At the age of 18, as many of you know, all eligible Israeli males and females are required to sign up for military duty. The IDF has less than 200,000 active duty personnel at any given time, but over 3 million males and females available for military service, and just under 500,000 in the reserves. They are a proud and diverse defense force with a distinguished record of achievement in defending their beloved country. And it may surprise you to learn that included in the IDF are non-Jewish members who have also distinguished themselves, such as the Druze, the Bedouin, and increasingly Arab Israelis who serve valiantly. With that basic understanding of the composition of the IDF established, and with a keen appreciation for the ever-present threats to the State of Israel, it's most appropriate to hear from our distinguished speaker and guest today. Colonel Eli Baran is a 20-year veteran of the IDF, where, among other posts, he has served as a military prosecutor and defense counsel, a military judge, a legal advisor, and now the number 2 JAG, or military judge advocate, for the IDF. As an IDF uniformed lawyer, he has real hands-on experience applying the rule of law in a vibrant country that is under constant threat, yet manages to preserve its rich historical and religious traditions in a modern market-based economy. So without further introduction, I give you the Colonel.
Thank you so much for this kind introduction, and thank you all for being here today. I'm very privileged and very honored to be here today on this fine white morning in Washington. I've been telling my hosts here that I've left an 85 degrees Israel just to be here. So, I mean, it's both a good experience to be here, and it also gives me something to think, something to wish for coming back home. As I was kindly introduced, I would say my military legal experience includes being both chief prosecutor and judge, both in the West Bank and in the Gaza Strip, where I gained extensive experience in prosecuting and judging terror attacks. I've dealt with countless cases of suicide bombings during the last 2 decades in Israel. I also acted as chief attorney and defense counsel for various groups of the IDF, of criminal cases of soldiers, sexual offenses, misconduct during operational activity. And I also acted as both deputy and chief legal advisor for the IDF in the West Bank, where I conferred legal advice concerning the military operations of the IDF in the West Bank, the agreements of Israel with the Palestinian Authority, numerous civil issues concerning both populations in the West Bank, both Israeli and Palestinian populations, and the engagement of the IDF with numerous NGOs and international organizations in the West Bank. One of the main issues in which I'm involved today is the operational activity of the IDF and its adherence to the international law. And what I would like to do with you today is address the issue of the changing nature of modern warfare, the IDF's challenges in applying the laws of armed conflict and international law, and the way in which we contend with all of these challenges in different stages of the operation, before operation, during the operation, and right after it ends. Now, all of these issues will have some operational aspects and some legal aspects, and I invite you, after my presentation is over, to ask about any of them. Just as a reminder, Israel has been involved in at least 4 major military campaigns in the last decade or so. We had Operation Defensive Shield in the West Bank in March 2002. Then we had the Second Lebanon War in July 2006, and 2 major operations in the Gaza Strip, Operation Castled in December 2008, and Operation Pillar of Defense in November 2012. All of these operations look very different from the conflicts Israel has faced in previous decades. All of these differences cause difficulties from an operational standpoint, but also from a legal standpoint. We now have new parties. Non-state actors, terrorist groups, are now engaging in full-fledged hostilities against the organized official armies of Western countries. These groups generally belie the principle of reciprocity that underlies the entire system of international law. State-on-state conflict, under the law of armed conflict, has been predicated on the assumption that if you abide by the rules, so shall we. if we think of prisoners of war. If you give them protection, we shall treat your POWs similarly. Yet, modern non-state actors not only violate this understanding, but deliberately exploit our commitment to the rule of law. And it's important to remember that we're not talking about just a ragtag bunch of idealists. Many of these non-state actors are more powerful and possess more weaponry than many state militaries. If we think of Hezbollah as an example, a non-state actor which is stronger than the Lebanese army, a terrorist group which holds sway in the Lebanese government. They are best based physically in southern Lebanon and in Beirut, but being supported financially by Iran, materially by Syria. Think of the operational and strategic difficulties this leads to. We also have new fronts. Modern conflicts have also extended into spheres previously left untouched. There is no longer a division between the battlefield and the home front, because the home front, in Israel at least, became the battlefield. Urban conflict is now the norm. Just an example, during Operation Pillar of Defense, a bomb went off in a bus in Tel Aviv. At the very same time, I was sitting in my office in the IDF headquarters, and I could hear the bombing because it happened right across the street. Middle of Tel Aviv, a civilian target, and that is the battlefield, our home front. And what about the time boundaries of the conflict? If we take the conflict with Hamas as an example, this conflict did not start with Operation Pillar of Defense. Israel has been involved in a conflict with Hamas since at least the year 2000, when Hamas unleashed a torrent of human bombs and terrorist attacks against Israeli civilians. It has transformed into incessant rocket fire from Gaza, fence line attacks against Israeli civilians and soldiers, and attempted kidnappings. This conflict has had its peaks and troughs in terms of intensity, but it has continued. Now, if you consider such a conflict, you must ask yourself the question, when would it end? The normal way to end hostilities is to sit down at a negotiating table and sign an agreement. But we don't see that happening anytime soon with a non-state actor such as Hamas. And this leads me to my final big issue: what is considered a victory when you confront a non-state actor? Last year, I was on an official visit to the Pentagon, and I've had the privilege to see the original instrument of surrender signed by the Japanese on the USS Missouri in World War II. Back then, it was very clear who lost and who won. But it made me wonder if there's any chance that we might be able to see such a document in the context of a conflict with a non-state actor. After the Second Lebanon War, there was no doubt that Hezbollah was totally and absolutely beaten militarily. They suffered enormous losses and had their military power decimated. Yet for them, that conflict is considered victory, because for more than a month, they withstood the might of the IDF, and for them, the damage to the infrastructure and the loss of civilian lives on their side is also part of the victory. Now, all of these wider strategic operational challenges also pose some serious legal challenges for us lawyers, that I would like to address now. Now, if we start with the legal framework, remember we talked about the temporal issue of the conflict. This issue also has some legal ramifications, some very serious ones. If we take Operation Pillar of Defense, some academics viewed it as the start of a new conflict. Now, if you would do that, you would be examining this operation from an entirely different legal viewpoint than if you did comparing to a continuing armed conflict. Now, the start of a new conflict is examined by us lawyers, but by what we call jus ad bellum, the legal criteria that must be met before setting out to conflict. Conversely, if we are already in an ongoing conflict, we will usually apply what we call the jus in bello, the legal criteria that all parties to the conflict must adhere to when carrying out military activities. And if we try to determine who is a part to the conflict, we will also contend with some legal questions. If we take the conflict with Hezbollah as an example, there is no question that Israel is in an ongoing military conflict with Hezbollah. But this is not so simple. Remember the fact that we said that Hezbollah is a part of the Lebanese government. So does it also mean that Israel is in an armed conflict with the Lebanese army? And if we take it a step further, Hezbollah is being supported heavily by Iran. Does this mean that Israel is in an armed conflict with Iran, who basically uses Hezbollah as an extension of its own forces? And what happens when Hezbollah takes the conflict to foreign shores by attacking Israeli tourists in Bulgaria or the Israeli embassy in Buenos Aires? Now, another thing we should tackle when analyzing the situation is what kind of conflict are we in? If we'll take the events of the early 2000s in the West Bank, these events basically challenged the fundamental dichotomy provided by international law, according to which either you are at war and apply the laws of armed conflict, or you are at peace and apply the paradigm of law enforcement. Now, those events, which included violent riots, incidents of live fire against Israelis, and organized armed groups acting against or fighting the IDF, suggested that while we were not at a state of all-out war, we were also not acting just as police forces. Now, one of the main principles that have to be applied, that has to be applied in an armed conflict is the principle of distinction. This principle is two-pronged. On the one side, you can only target combatants and military objectives and distinguish them always from civilians and civilian objects. And then, on the other side, one cannot endanger one's own civilian population for military purposes. That means that the presence or movement of civilian population cannot be used to render areas immune from military operations, including shielding military objectives from attack. Now, it may look like a straightforward rule, but applying it in our context raises a myriad of complex and vexing questions, which I would like to examine a few of them now, if you may. Can you see it? Yeah. Now, if we'll have a look at this picture, these are Hezbollah combatants, which makes them a very clear, distinguishable, identifiable, and targetable entity. But what about this picture? Here it gets a little more difficult. We see people in civilian clothing, yet clearly they are carrying weapons. They seem like a targetable entity, yet it starts to cause some operational complexities because our forces are forced to distinguish between them and civilians not involved in the hostilities and start to enter legal gray areas of determining who is a combatant. Now, I think that this picture even highlights that dilemma more, because what we see in this picture is a truck which is obviously a military objective, yet have a look at this driver, who seems like a harmless civilian fellow, but can we classify him as a combatant? And if we do, at what stage do we do that? Only while he's driving the truck, or before and after? And in this picture, we see the Hamas police force in the Gaza Strip. Generally, we would not consider police as active participants in the hostilities. Yet, despite their blue uniforms, the type of weapon that they carry suggests an entirely different role as active combatants, as was the case in numerous occasions in Operation Cast Lead. And over here, we see a Hamas politician wearing a military garb and carrying a weapon. Does this automatically make him a lawful target? What it certainly does is raise problems. Because if this man is a lawful target and is attacked, and then the media portrays the strike as against a politician, the negative impact could be large. And in this last picture, we see a Hamas military operative wearing civilian clothes, but obviously taking direct part in hostilities by launching a rocket. Now, this question also raises the more fundamental question of distinguishing between military wings and civilian wings of the same organization. Recently, the European Union has designated the military wing of Hezbollah as a terrorist organization. But how can we distinguish this wing from the civilian arms of the same organization? Our Supreme Court, in many contexts, has recognized the purpose of the civilian arms of these groups to support and finance the activity of the military wings. But does it also mean that we can target members of the civilian arms? Now, the same applies for civilian objects and military objectives. Terror organizations like Hamas and Hezbollah deliberately use residential areas as military operating zones. They store weapons, fire rockets, and hide in and amongst the civilian population. Doing so raises some operational and legal challenges that I would like to see with you. First picture, a military base. Many Israeli bases will look like this, and it's a clear and identifiable target. But what about this picture? This one looks like a residential area flattened. But this is the Dahya, a suburb of Beirut in full control of the Hezbollah, used primarily for military purposes, a clearly lawful target, yet one which is embedded within a surrounding civilian population, and one which can have a devastating PR effect once struck. And the perfect dilemma. The Shifa hospital in Gaza, built by Israel at the time, during Operation Cast Lead, the basement of the hospital was used as a command center for senior Hamas commanders, a legitimate target with a considerable military advantage, but as you can imagine, the IDF did not strike. And in this video, which I hope will work, we didn't check that before. It's not working. Never mind. What I wanted to demonstrate is a way in which Hamas...
Your fingers are too fast. There you go.
I'll try again.
Yeah.
Bear with me. Okay. What we see here is the way Hamas launches rockets from within an urban territory in Gaza. It demonstrates how Hamas intentionally launches attacks from civilian environments in an attempt to elude a counterattack by the IDF, and how it fails to distinguish itself from the civilian population like it must. Simultaneously, these terror organizations deliberately and systematically target our civilian population. They are proud to fire indiscriminate rockets towards our civilians and bring their activities as far into the home front as possible. Our Prime Minister calls these double war crimes, targeting our civilian population while endangering their own. For example, in this picture from Operation Pillar of Defense, you can see a rocket that was launched from the Gaza Strip hit an apartment in Kiryat Malachi, causing 3 civilian casualties. Another basic principle of the law of armed conflict is the principle of proportionality. This rule requires that when an attack is expected to cause collateral damage, which would be excessive to the military advantage to be gained from the attack must not be carried out. This principle is one of the most important and difficult to carry out in our context. If we'll take this map as an example, taken from CAST-led operation, we can see the complexity in the modern battlefield in the Gaza Strip, which is probably the most densely populated region in the world. In red, we see clear military objectives, and in yellow, we see schools, mosques, and other sensitive sites. One can easily comprehend the difficulty to attack military objectives without collateral damage to the sensitive sites. Same here in a map taken from the Second Lebanon War. In red, we see military objectives, and in blue, we see sensitive sites like medical facilities. There are more important things, some very important things to remember when considering the principle of proportionality. First of all, this is not an exercise in hindsight. The focus is on what the commander anticipated under the circumstances and not on what the end result was. It is a sad and regrettable fact that during military operations, civilians might die, sometimes beyond what we expected or anticipated. However, this does not mean that there has been a violation of the law. Similarly, proportionality is not a comparison between the body counts on either side. We sometimes hear egregious claims according to which the fact that there are more bodies after an operation in Gaza than there are in Israel, Israel is being disproportionate. The explanation is simple. Israel actively defends its citizens, investing in defensive infrastructures such as the Iron Dome defense missile system, and forcing its civilians to go into shelters while under attack. At the same time, Hamas intentionally and systematically endangers its civilians by deliberately placing them in the line of fire so as to deter Israel from attacking them and exploit civilian harm in the international arena in the case we do attack. Now, this has nothing to do with the legal proportionality that I'm talking about, which is an analysis of each attack individually and separately, and the relation between the expected collateral damage and the military advantage to be obtained. Now, after I've raised a number and not all of the difficulties that modern conflict poses from a legal and an operational standpoint, please allow me to present how we contend with these issues in every stage and aspect of the conflict. We have instituted a robust system of commitment to the law within the military. For example, each soldier is obligated to abide by the Geneva Conventions by an explicit IDF order, and we also have specially designed programs to teach soldiers and officers about the laws of armed conflict. With regards to specific operations, we provide ongoing advice to all levels of the chain of command. This legal advice touches on a wide range of issues: legal assessment of targets, weapons, detention of combatants, protection and treatment of the civilian population, etc. In a case active hostilities are instigated, we operate what we call the operational law apparatus, which is basically a bank of officers who in time of emergency are called up to provide operational legal advice to forces in the field. We also set up a 24-hour legal war room. Now, I mentioned before that we are assessing the legality of targets. The IDF collates its targets according to strict legal guidelines and policy restrictions. There are also a number of additional steps that we take to ensure that our strikes result in the minimal incidental harm. Please allow me to present some of them. First of all, we always use cross-verification of intelligence, and I would like to show you an example in which we'll see, if we'll see, takes a while, eh? Yeah, okay. Again, what we see here is a strike on a house that may look like an innocent civilian house, yet if you look at the red arrow at the right, you see a secondary explosion that clearly indicates that in this house were stored munitions. Otherwise, we wouldn't have seen such an explosion. Now, we also pre-plan our attacks. Pre-planning includes assessing each target from many different angles. For example, if the target is a weapon warehouse next to a school, the decision to strike the target at nighttime when no students are present could be made. We also use real-time visual coverage that helps us to monitor the changing circumstances and implement the rules, such as the principle of proportionality. And we can even decide on what angle to strike the target from, so as to ensure that any fragmentation goes away from adjacent civilian buildings and not towards them. You've seen the coordination maps that we use with all the sensitive sites marked on. We have an extensive system of cooperating with the numerous NGOs in order to gain more information concerning the different locations of sensitive sites, so we will be careful when attacking in these areas. We also have a developed and sophisticated system of early warnings prior to attacks. The law of armed conflict requires that precautions be given prior to attacks where harm to the civilian population is expected in certain circumstances and only where feasible. Our system goes far beyond that. What we see here is a leaflet in Arabic, one of more than 2 million leaflets that were dropped over the Gaza Strip in both last operations, providing the population with knowledge, information about the areas in which the IDF intended to operate and the routes to escape these areas. We also make phone calls to people's homes, letting them know that we are about to attack a house in which they are at the moment, or a house near them, and giving them the time to evacuate the environment in order to avoid harm. Unfortunately, this is not always effective and is sometimes manipulated, as you'll see in the video clip that I'm showing you now. Please read the subtitles. I'm sorry for not having sound. We also use precision munitions that in some instances are giving us the capacity to divert or even abort strikes once they have already been launched. In this video, we can see the Israeli Air Force targeting a Hamas operative in a vehicle who drives directly into an area where there are civilians. Even though the missile has already been launched towards a legitimate target, the Air Force is diverting it in order to avoid civilian casualties. Now, our role does not end when the operation is over. After each operation, it is crucial for us to learn from the past experience and improve in the future. And it is at least important for us to investigate any allegations of misconduct by our forces and to properly punish any perpetrators and create deterrence for others. We have a robust and extensive, independent and effective system for investigating alleged violations of the laws of armed conflict. Obviously, we have many difficulties in carrying out such investigations. First, we have no access to the scene of the event. I mean, no one is going to let IDF investigators into the Gaza Strip to have a look at the scene of an event where Israeli soldiers have operated. The scene is also open to manipulation, in many cases, by the adversary. In some cases, military strikes, as we have seen, destroy the evidence. So while we may know that a specific target was used as a weapons warehouse, after targeting it, we cannot prove it, except by intelligence, which is usually classified and cannot be substantiated to show the basis for our decision to close a case. Now, there is also an obvious aversion on behalf of the local witnesses or authorities to assist us with the investigation. There could be interference with witnesses giving testimony by the Hamas authorities, and it would certainly take some courage from a resident of the Gaza Strip to admit that Hamas was firing from a civilian area. There is also a problem of finding a place to interview the witnesses who reside in enemy territory. In order to deal with that, we established a special mechanism for taking testimonies from witnesses in a cross point between Israel and Gaza, and using the cooperation of numerous NGOs in that effort. This is the nature of modern warfare. Democratic states committed to the rule of law are fighting against groups that not only violate the law, but exploit our commitment. And when the fighting ends, allegations of international law infringements, no matter their veracity, may cause serious damage before we have the chance to investigate and refute them. The result is that not only is it harder for our forces to contend with these challenges operationally, but that the media and public opinion receive a lopsided account without the benefit of a proper and well-considered response by all sides. We've mentioned all of the legal challenges that we have in this issue. We find comfort that the cooperation and support from like-minded states will continue to help us to contend with these challenges successfully, because we know that you also face the same challenges. Israel, as a democratic state accountable to the rule of law, is fully committed to our international law obligations. Where allegations of violations arise, we thoroughly examine them, and where necessary, we take the appropriate steps to punish, rectify, and ensure that it does not happen again. Let me refer you to one of my favorite quotes by the retired Israeli Supreme Court Chief Justice Aaron Barak that suggests that our upper hand in the fight against terror stems from our commitment to the rule of law. Our reputation and place in the international community, our morals and values as a nation and a state all require that we go beyond our legal obligations and ensure that we act properly and carefully when conducting military activities. We do this regardless of our adversaries' shameful conduct. I hope that the examples and explanations that I've offered today provided some food for thought, and I'll be delighted to get your questions now.
Well, thank you for a very interesting and stimulating discussion, Eli. I was struck, and I'll just take the prerogative as the moderator to make an opening comment and then a question. I was struck by how similar your application of the rule of law is almost indistinguishable from the way we approach applying the rule of law in the law of armed conflict, especially in active hostilities, as American military lawyers. Your PowerPoint presentation, which I'm glad to see the Pentagon is not the only institution that's been infected by PowerPoint presentations. I'm glad to see Israelis using it as well. Could have easily been given by an American judge advocate to their own troops. And for those of you who want to read more about how we look at the four principles of the law of armed conflict, proportionality, distinction, etc., you can read my testimony before the full Senate Armed Services Committee, which is available on the Heritage website from last May 16th, 2013. Let me get to my question. One of the most contentious issues that the United States faced early on in the war that we joined on in September of 2001 was what rules, what rights do captured al-Qaeda and Talibanis receive? Are they entitled to the full protections of the Geneva Conventions? If not, what section, if any? And I was struck by your comment about Hezbollah and the political association with a country, and then are you actually at war with the country? We had, as you know, had to cross that threshold early on because the Taliban was the ruling party of Afghanistan, but only 3 countries represented the Taliban as the legitimate ruling party of Afghanistan, but Afghanistan signed the Geneva Conventions years before. So we decided as a matter of law that captured Taliban fighters would receive the Geneva Conventions if they followed the rules of war. Well, of course, they didn't follow them, so they lost the majority of them except for the basic protections under Common Article 3. If you could, when you take into custody somebody under the law of war paradigm, not criminal law, what happens to them? Are they do they have to go to trial? Can they be detained without charge? Walk us through that, because I think for us as Americans, that has been the big rub for us since 9/11. Of course, I think we all now realize you can detain people without charge under the Geneva Conventions for the duration of the hostilities. You can choose to try them if you want for articulable war crimes. I'd be curious to hear that.
So there are basically,
why don't you come over here to that?
Yeah.
Thank
basically, you. We have a few different routes that we operate in this subject. If we put aside the West Bank, because Israel is still controlling some major or big area of big parts of the West Bank, and when arresting a terrorist from the West Bank, we usually use the usual criminal legal system that we have. If we'll take Hezbollah or Hamas in the Gaza Strip, we have 2 routes that we operate in. First one is our criminal courts. Obviously, the detainees that we have from these areas do not enjoy the protection of the 3rd Geneva Convention. And when they launch hostilities against the State of Israel, they also do not abide by the legal code of the State of Israel. Therefore, can be brought before a court, a military, not a military, a criminal court inside the State of Israel. Another unique tool that we have is a law that was enacted in 2002, which is called the Unlawful Combatants Act. This act allows a military commander to arrest for an open, in an open time for indefinite time a detainee that cannot be classified as a prisoner of war according to the stipulations of the Third Geneva Convention. He'll be brought to a periodical judicial review before a magistrate, district court in the State of Israel. He has the right to appeal to our Supreme Court every 6 months, and we've done it in numerous occasions. So these are basically two different tools that we can use in such situations.
Mm-hmm. Very interesting. Folks, so we want to have you join the conversation, and with the two standard heritage caveats, that is, please wait for the microphone and then state your name and your affiliation and then actually ask a question. And of course, I have the prerogative to cut you off if you start speechifying, but I'm sure I won't need to do that. So please raise your hand if you want to ask a question. The lady in the back with the glasses.
Hi, my name is Becca Smith. I'm from CSIS. First, I wanted to thank you both very much. Thank you for your presentation. And like Captain Stimson said, I find that the application of ethics in the military justice system to be almost identical. Mm-hmm. A question for you, sir, is how do you measure success? How do you, against these adversaries? Is it in reducing the percentage of attacks? Is it reduced Israeli civilian casualties? How do you measure success? Thank you.
Well, I guess you are talking about an operational success. We view it we take into account a few factors. First of all, obviously, we want to minimize the civilian losses on our side. And we, as I said, invest heavily in the infrastructure that will allow us to do so. And we are also very harsh in means of discipline towards our civilians when it comes to attacks. They have to go to shelters, and they know it. And I can tell you from my own personal experience that while I was in the subterranean war room in the Operation Pillar of Defense, my family, living near Jerusalem, had to go repeatedly to our secured room inside the house. We have a concrete reinforced room. Every house in Israel has to have one, and they had to go there again and again and again. Okay, so this is one factor of protecting our civilians. Another very important factor for us is minimizing the civilian losses on the adversary's side. The bigger the number of civilian losses will have, the smaller extent of success that we'll ascribe to the operation. Now, as I've shown in numerous examples here, we actually, in my opinion, set the bar in so many issues concerning the effort to minimizing the civilian harms on the adversary's side to an unprecedented height. I don't know any other nation that applies such an extensive system of early warnings, of calling people to their homes, to their cell phones, letting them know that there is an impending attack towards their house or the neighbor's house. We also have a procedure I didn't discuss. It's called knock on the roof. When you have a suspicion that there are still people in the house that you intend to attack, we will usually not attack the house immediately, but rather launch a low precise munition rocket towards the corner of the roof of the house in order just to shake the house, cause a large sound, and let the people inside the house that they should evacuate. Now, the population in the Gaza Strip, they know this procedure. I've seen a video not so long ago in which people in Lebanon were interviewed about the fighting in Syria and how it has a spillover to Lebanon. And what they said, residents of an enemy country in our eyes, what they said that all militaries in the world should strive to learn from the IDF in the way it operates while in an armed conflict. They said in 2006, when the IDF was operating here, we received leaflets. They let us know exactly where we should go in order to avoid harm. They marked on the map exactly which routes we can use that will be immune from attack, in what hours we can use these routes. So for us, it's very important. It's very important. It's part of the effort, and we'll definitely measure our success by the number of civilian casualties on the other side. And of course, we also measure it by ways of knowing or checking how long was the lull or the ceasefire actually effective after the end of the operation.
And I think part of your question was the strategic success versus the tactical. And of course, you know, as a uniformed lawyer, me or Eli or anyone else in the military, I mean, that tends to be with the political elders well above you. I would be remiss if I didn't mention, and you can certainly confirm this, that there's a very good working relationship between our military and your military, and we've actually learned a lot from the JAGs of other militaries, and they've learned from us. This long war has resulted in a lot of military-to-military discussions and learning lessons, such as, you know, early on, I know some in your country were encouraging us, for example, for the detainees at Guantanamo, to have them have lawyers and have access to courts. And in fact, ultimately that ended up happening. And you see that some number of them, 155, are still at Gitmo from a top number of 779. Next question. Sir, over here on the left.
My name's Nathan Lacombe from Lutheran College, Washington semester. Given that there's so much asymmetrical conflict going on in that region of the world, what are some forms of deterrence utilized to stop such, so like before conflicts happen, what do you try to do to stop them from attacking you first, I guess?
Well, I think the best way to deter such groups is to show them that we are very restrained as long as they are restrained. And if you take the Gaza Strip, for example, we have been very lenient in allowing the calm in the Gaza Strip, the moving of any goods they need inside the Gaza Strip. May I remind you that we are under no obligation to allow the transfer of goods inside the Gaza Strip. This is an enemy territory, and we are not obligated to allow the transfer of goods over there. Yet, most of the goods inside the Gaza Strip arrive from Israel. And I think that if the population, which is basically these terror groups, have to operate inside the population, and I think there's also some, you know, balance of tolerance between the terror groups and the population. They cannot ignore the public opinion of the population in which they operate. If the population receives a message according to which, as long as you stay calm, we will get any support needed from the State of Israel, I think this is a kind of deterrence which is not military. And then when this balance is stopped or interrupted by more attacks, I think that the IDF has shown its might in all of the operations, and I think that it's respected, well respected, as I've shown with the example of Lebanon. It's well respected by the population on the other side, even though it's an adversary's population, our adherence to the rule of law. So if, as I may have understood your question, if you allude to the question whether maybe in this kind of a conflict we have to, follow other rules of or laws of war, create new rules, we don't find it necessary. We think that even though the laws of war, the rules that are at hand, are maybe 60, 70 years old at least, and may not be perfect for the current conflict, we find it very important that they will be adhered to, and that we'll have a framework, a legal framework in which we operate. Otherwise, we will be lost.
And Eli, correct me if I'm wrong, but the periodic review that you provide detainees comes directly from Common Article 3 to the Geneva Conventions. Sure. Yeah. Next question, the lady in the middle here with her hand up.
Danielle Mueller from LCWS again. Could you talk a little bit about the procedures that Israel has in place if a member of the armed forces was found to not be following the 4 principles of IHL? If an attack took place that didn't comply with IHL, what would happen afterwards?
Sure. We'll take Operation Pillar of Defense as an example. What we did the day after the operation ended, and I stress it out, the day after the operation ended, it didn't take us not 1 week or 1 month or half a year. The day after the operation ended, I gathered my officers, and we considered the number of incidents that happened in this operation. It was, in our perspective, a rather limited operation, and we decided on the policy for investigating incidents on that specific operation. What we decided was that even though we have no obligation whatsoever to investigate any incident in which a civilian died, because in many cases civilians, as I said, may die, and this does not mean in any way that the attack was unlawful unless the attack was directed at the civilian, which was never the case. We decided to check all of these incidents in order to learn from them. We decided to check all the incidents in which there was damage to civilian infrastructure or communications infrastructure. And then what we did was to establish a special committee headed by a general in the IDF whose sole purpose was to gather all the information from all the different combat units in the IDF. You get the information, you check each incident separately, and you check whether there is a suspicion for violation of the laws of armed conflict. If there is such a suspicion, we will immediately order a criminal investigation. We have the military police who investigates these cases, and then obviously we will receive the file and decide whether there's basis for an indictment. or we have to close the file, or sometimes order on disciplinary measures. Unlike the American system, in our system, the commanders are not involved in the process of investigation and indictment unless we ask them to gather the information like I just mentioned. The JAGs in my unit enjoy full professional independence according to law. We will never be swayed by anyone who will try to interfere with this process. And in some cases, if there's an apparent breach of the law, such, I don't know, a case of pillage, or any other case in which, you know, mistreatment of detainees, we will order a criminal investigation instantly.
And just for your edification, in terms of the U.S.'s approach in this context, we've detained over 100,000 individuals since 9/11. The vast majority were in Iraq. About 30,000 or so were in Afghanistan, and a mere 779 were in Guantanamo. We don't have anyone in Iraq. We have a baker's dozen in Afghanistan now that we're interested in, who are continuing enduring security threats. And then we have 155 at Gitmo. But of those 100,000 detainees, some number of U.S. soldiers, sailors, airmen, Marines committed articulable crimes against detainees, and they were prosecuted. And we've actually written a paper here, a special report that I helped co-author with Alyssa Hazelwood in the back of the room, on understanding the military justice system in the context of sexual assault in the military, and we explain in detail how investigations in the U.S. criminal justice system in the military is actually outside the chain of command, but the commander plays a role in enforcing good order and discipline, and that's available on the Heritage website as well. All right, next question. Ma'am in the back.
I'm Ji-Suk Lee from Korea. You mentioned the Iron Dome. If you could assess that weapon, how has it been effective in preventing or deterring Israel from the enemies of Israel?
Well, obviously it's been quite effective in the last operation of Pillar of Defense. It managed to intercept a significant part of the rockets that were launched towards Israel. The number, if I'm not mistaken, during that week, there were about 1,600 rockets launched towards our cities. And thank God, many of them either didn't hit any civilian target or were intercepted. However, we did have some cases in which civilians died, like we've seen in the presentation. But it's not a perfect system. Obviously, it has its limitations, and obviously it's classified, so I won't be able to refer to that. But thank you.
We have time for one more question for the Colonel. Please raise your hand. Well, let me ask, since there are no hands, because sometimes people don't ask the obvious question. Have you enjoyed your military career? How did you get to be the #2 JAG in the IDF? And how long can you serve in uniform in the military? Typically in our armed forces, if you're the Deputy Judge Advocate General, you're a 2-star admiral or a 2-star general, and then you fleet up to become a 3-star. Tell us just a little about your career.
Okay. Well, first of all, I never wanted to be a lawyer. When I was in high school, my wish was to go to a combat unit, one of our elite units, and for 2 years I did the ridiculous thing of running with a backpack full of stones on my back. But unfortunately, the Army found some physical disability that I had that did not allow me to go to a combat unit. and I decided to join the academic reserve. I don't know why I joined the law studies of all things, but that's what happened, and here I am. My military service has always been tremendously interesting. I think what's very unique in the legal service of the IDF is the fact that it gives you an opportunity to experience some tremendous legal challenges at a very early stage of your career. There is no way I could ever have received cases of the terror attacks that I received after 1 or 2 years in the civil system. It would have taken me at least 15 or 20 years to get the opportunity to prosecute such cases, which obviously has been a tremendous experience for me. Yet I also, I mean, there were many points in which I wanted to leave my service. About 10 years ago, I'm telling you a very private thing at the moment. About 10 years ago, I already decided to leave the army. And my commander back then, who later became the military advocate general, and is now the secretary of the Israeli cabinet, he sent me on a delegation of IDF officers to the death camps in Poland. And I've been there for a week, and I came back as a wreck. I could not contain the horrors that I've seen over there, or comprehend what has happened in those years of the Second World War. And it shook me that hard that I decided I cannot leave the army. And it gave my whole service a totally new perspective and context, and a drive to go on, understanding what having this army means for my people. And here I am.
Thank you very much.
Thank you.
We stand adjourned.